Today we will be discussing the legal foundation and the shift in jurisprudence. And this is especially highlighting the case of Consumer Protection Act for the healthcare professionals as well as for the advocates. So this case was primarily done for the advocates. But in that, observation was made that whether doctors' role should be governed by this case or not. So if we remember the history, in 1995, there was a case of VP Shantha, and that made doctors liable under the Consumer Protection Act. Before that, doctors were not covered into the Consumer Protection Act. After this verdict, doctors were covered into this. In 2024, you see, after approximately 29 years, DK Gandhi questioned this precedent and referred it to the larger bench. So what do we mean by larger bench? Basically, there are different types of benches into the court. So there is a single judge who is passing the order, and if two judge bench is there and that is superseding the order of single judge, that order prevails. And if larger bench, mean to say 3 judges, 4 judges bench is there, so larger the quorum size, the authentic the decision is made and the previous decision is quashed. So in this case, DK Gandhi questioned this precedent. Which precedent? VP Shantha, that doctor should be included into the consumer court or not, and referred it to the larger bench of 3 judges. DK Gandhi excluded in this case advocate from Consumer Protection Act. They are saying it is a contract of personal service. There are two types of contract. One is contract of personal service and there is contract for personal service. Contract of personal service is like the services rendered to the particular person. It is not governed by the commercial relationship. And if we say in a more larger way, so employer-employee relationship is also contract of personal service. Contract for personal services are given under the name of professional services or commercial services. So contract for personal services are covered under Consumer Protection Act, and contract of personal services are excluded from the Consumer Protection Act. So the whole debate is that is it contract of personal service, mean to say doctors have to be excluded from the Consumer Protection Act, or it is contract for personal services. If it is applied, then doctors are included or governed by the Consumer Protection Act. So this case has opened the path for re-examining that doctor-patient relationship under this lens. Mean to say that doctor should be covered or should not be covered has to be re-examined. It has to be seen by the larger bench. They have to examine the validity of this VP Shantha case, that if advocates are excluded, then why doctors are not excluded from these services. So reinterpretation is required. So this kind of referral is known as reinterpretation, legal reinterpretation. You see, the laws are made in parliament, but the interpretation of the law is made by the courts. So reinterpretation means it has to be re-examined, and the effectivity and the effect on the doctors are getting re-examined by this.